Good afternoon, everyone, and welcome to this month's edition of Mind What Matters. I'm John McDonough, President and CEO of the Greater Vancouver Chamber of Commerce, and I want to welcome you to today's program. These webinars are designed to offer important, relevant information and resources to the business community. The recordings of these webinars are always available and will be sent to those attending after today's event, and as well can be found on our website at the Greater Vancouver Chambers or at the Greater Vancouver Chambers YouTube channel. So our Mind What Matters series sponsors support this program. Support of the program allows us to bring to you this webinar series at no cost. Please keep our sponsors in mind when you're in the market for their products or services. And our series sponsors include Delta Dental, Pacific Source Health Plans, Sprout Partners, Peace Health Southwest, Northwest Natural, the Peak Fleet, Columbia Bank, Obsel Dawson, Waste Connections, and On Point Community Credit Union. If you're interested in visiting with any of those sponsors, you notice that their banners were posted around the floor that you were placed into when you arrived, and you can click on those to get more information. Now, today's webinar is presented by Bob Joy, one of the Employment Security Outreach Specialists at Washington State Department of Labor and Industries, referred to by many of us as L&I. I'm sure you'll enjoy Bob and his presentation. Bob has a very rich and diverse background. He grew up on a wheat and cattle ranch in north central Washington, graduated from Gonzaga University and law school, and his career saw him as a lobbyist, teacher, professional parliamentarian, sportscaster, and volunteer firefighter. Bob has put together a very comprehensive presentation for us today with reference to a variety of additional resources. If you have questions during Bob's presentation, please put those in the chat and we'll try and address as many of the questions as time allows for this afternoon. And Bob, I see you've joined me on the stage, so let's begin the presentation.
All right, thank you. Thank you for allowing me to share time with you today. This presentation will be an introduction to the Employment Standards Program, more specifically the laws the department enforces when it comes to wage and hour. I am an Employment Standards Outreach Specialist at the Department of Labor and Industries. At the conclusion of the presentation, I will make time to go through any questions you may have and provide the answers I can. If I don't have the answer, I will work to find it for you. I have emailed a PDF version of the PowerPoint used in this webinar to the organizers to be distributed after the presentation. The Department of Labor and Industries' mission is to keep Washington safe and working. Our Employment Standards Program enforces laws dealing with wage and hour issues, including minimum wage and overtime, paid sick leave, youth employment, agricultural employment, and ensures that employees are provided all the employment standards protections they are entitled to. All employees in the state of Washington are protected by the regulations enforced by L&I, regardless of their legal status or the number of hours they work. Here is an overview of the many topics that we will cover today. We will review the Minimum Wage Act protections, pay requirements, meal and rest period requirements, specific program regulations, the workers' rights complaint process, and other resources available to you. I'm going to begin with the Minimum Wage Act overview. This includes protections such as the right to earn at least minimum wage, the right to overtime for hours worked over 40 in a work week, the right to earn tips and service charges, the right to accrue and use paid sick leave, and protection from retaliation and discrimination for exercising protected rights under the law. These protections apply to most employees except those who are specifically exempt from state law. Please review Administrative Policy ESA 1 on the applicability to the Minimum Wage Act, and you will note that at the bottom of many of these slides there appears a More Info tab, which includes links to important resources for you. Employees must be paid at least minimum wage for every hour worked. As of January 1st, 2023, the minimum wage rate is $15.74 an hour. Workers aged 14 to 15 years old may be paid 85% of the minimum wage, or $13.38 per hour. Some local jurisdictions have higher minimum wage rates and different labor rules than Washington state. The more generous minimum wage may apply in these locations, such as Seattle and SeaTac, and we are also aware of Tukwula's new wage going into effect in July. Please see the link at the bottom of this slide for more information on the minimum wage. Most employees who work more than 40 hours in a 7-day work week must be paid overtime. Overtime pay must be at least 1.5 times the employee's regular hourly rate. Employees cannot waive their right to overtime pay. Some employees must meet a specific exemption in the law to be exempt from overtime. The most common overtime exemption applies to white-collar salaried workers in an executive, administrative, professional, computer professional, or outside sales role, and individuals who don't meet the definition of employee under the Minimum Wage Act. Please see the link at the bottom of this slide for more information on overtime eligibility. Employees must be paid for all work performed at the rate agreed upon with their employer. This rate can be an hourly wage, a salary, a flat rate, a piece rate, commission, or a combination. When an employee is paid hourly, they must be paid for all hours worked. There are 3 elements to the definition of hours worked. 1, an employee is authorized or required by the employer. 2, to be on duty. 3, on the employer's premises or the prescribed workplace. If any of these 3 elements is not satisfied, then the time spent is not considered hours worked. An analysis of hours worked must be determined on a case-by-case basis depending on the facts. See the link at the bottom of this slide for more information on getting paid. Tips are amounts freely given by a customer to an employee. Employers must pay all tips due an employee, and they cannot be counted towards a state minimum wage. Employers must ensure that they do not take tips for company use or to pay employee wages. A service charge is a separate designated amount of money collected by employers that appears to be for services that an employee provides. The service charge requirements are directed to specific businesses, including but not limited to restaurants, catering houses, convention centers, and overnight accommodations. Service charges are in addition to hourly wages paid to the employees serving the customers. Under state law, an employer that imposes a service charge to a customer must disclose on the receipt and menu how much. If any portion of a service charge is not clearly designated as being retained by the employer, it is due to the employee or employees serving the customer. Please see the link at the bottom of this slide for more information on tips and service charges. Employers must provide their employees with rest periods. Rest periods must be paid to employees on the employer's time. They must be a minimum of 10 minutes for every 4 hours worked. You can choose to give your employees a rest break of more than 10 minutes, but the law requires that it must be at least 10 minutes. And it must be a paid rest period free from duties, meaning the employees are not required to work during their rest break. Employees cannot be required to work more than 3 hours without a rest break, and the break must be given by the end of the 3rd hour. Since they are paid required breaks, employees cannot waive their right to them. Meal breaks are usually not required to be paid. We say usually because there are instances in which they do need to be paid. If you require employees to remain on duty during their meal break, or to remain on call on the premises or work site in your interest, even if they are not called back to duty, or if you call an employee back to work interrupting their meal period, in each of these situations, you must pay the employee for their meal break. Employers are not required to pay for a meal break if the employee is free from all duties for their entire break. Unpaid meal breaks are not considered hours worked, and meal periods must be at least 30 minutes in length and must be given for every 5 hours worked. And unlike rest breaks, employees over 18 may reach a mutual agreement with their employer to waive their meal breaks. However, the meal period must be reinstated if requested by the employee. While these are the standard requirements for meal and rest periods, please note there are separate, distinct requirements for minor employees and agricultural workers. See the link at the bottom of this slide for more information on rest and meal breaks. As of January 1st, 2018, most employees are entitled to 1 hour of paid sick leave for every 40 hours worked. This includes part-time and temporary employees. Workers that are exempt from the definition of employee in the Minimum Wage Act are also exempt from paid sick leave. Sick leave accrual begins on the employee's first day of work. Employees may start using their earned paid sick leave 90 days after their first day of work with their employer. Employees may use paid sick leave to care for themselves or their family members, such as a child, a parent, a spouse, a grandparent, a grandchild, or a sibling. They can also use accrued paid sick leave if their child's school or place of care is closed for a health-related reason, like the recent closings during the pandemic. Accrued sick leave may also be used for absences related to domestic violence. See the link at the bottom of this slide for more information on frequently asked questions concerning COVID-19. There are also certain notification requirements that employers must follow. Employers must provide employees with a one-time written or electronic notification outlining their paid sick leave rights. This information must be readily available to all employees and provided to them no later than their first day of employment. You also must provide employees with regular statements, at least once a month, with the amount of paid sick leave accrued, amount used, and balance remaining for use. The employer can decide how they are going to inform employees of these totals. Some employers will provide this information on the employee's pay stubs, or they may have an online system where employees can access this information. Employees may carry over up to 40 hours of unused paid sick leave into the following year. Employers may adopt a more generous carryover policy than what the law requires if they choose. Employers do not have to pay out unused leave at termination, but must reinstate any previously accrued unused paid sick leave if they rehire an employee within 12 months of their separation. And this includes employees hired at a different location for the same employer. See the link at the bottom of the slide for more information on paid sick leave, or contact the LNI paid sick leave specialist, Nick Burrow. There are several laws which provide protected leave for employees. Let's start with the Washington State Family Care Act, RCW 49.12.270. The Washington Family Care Act, FCA, allows employees to take any paid leave offered by their employer to provide treatment or supervision for a child with a health condition, or to care for a qualifying family member with a serious or emergency health condition. Employees can choose the type of paid leave benefit they want to use, such as paid sick leave or paid time off. FCA is not separate leave, but it is available for employees who have other types of paid leave accrued and available for use, such as vacation time, paid time off, personal holidays, comp time for government employees, or specific short-term disability plans. Leave under the FCA is not available for an employee's personal medical condition. It can only be used for a qualifying family member. The Washington Domestic Violence Act, RCW 49.76, provides reasonable leave for victims of domestic violence, sexual assault, or stalking, or their family members. Victims and their family members can use domestic violence leave for legal or law enforcement assistance in court proceedings, medical and psychological help, help from social service programs, safety planning, or relocating. Leave for spouses of military personnel, RCW 49.77. After receiving a notice of impending call or order to active duty, the employee who is the spouse of a military member may take up to 15 days leave per deployment. Their spouse must be a member of the Armed Forces or National Guard to be eligible. This leave also applies to reservists who have been called to active duty. And it can be used for either before or during deployment, allowing spouses the ability to spend time together. And finally, leave for certain emergency services personnel, RCW 49.12.460. Employers with 20 or more full-time employees must allow employees who serve as volunteer firefighters, reserve peace officers, or Civil Air Patrol members to arrive late or be absent from work because they are currently working at or returning from a fire alarm or emergency call. Please see the link at the bottom of this slide for more information on protected leave, or contact the protected leave specialist, Jay Scoville. Some employers provide vacation, holiday, and bereavement leave, but these are not required by the law. If an employer offers these benefits as part of the employment agreement, they become enforceable under the agreement. The Equal Pay and Opportunities Act prohibits gender pay discrimination and promotes fairness among workers by addressing business practices that contribute to income disparities between genders. Both employees and job applicants have rights under the law. Employees have the right to equal pay and equal career advancement opportunities not based on gender. The law lists some permissible bona fide factors to justify different compensation or promotional opportunities, but gender cannot be one of them. Some of those bona fide factors include education, training, experience, having a seniority system, a merit system, or based on job performance, and a system measuring earnings by quantity or quality of production. Employers also have the right to have open wage discussion. Employees also have the right to have open wage discussions with others. And employees also have the protection from retaliation. An employer cannot take an adverse action against an employee for exercising their rights under the law. Access to wage or salary information of a new position or promotion upon request by the employee. And as of January 1st, 2023, employees also have the right to have access to the wage scale and salary range, general description of benefits, and other compensation on internal job openings. These last two requirements do not apply to employers with fewer than 15 employees. Job applicants have the right to have access to wage scale and salary range, general description of benefits, and other compensation on job openings. This requirement does not apply to employers with fewer than 15 employees. Job applicants also have the right to wage and salary history privacy. Employers cannot seek the wage or salary history of an applicant. An employer may confirm an applicant's salary after the employer negotiates and makes an offer of employment, including pay to the applicant. Job applications cannot ask for an applicant's previous salary, even if that section is not required or is optional. Employees can voluntarily disclose their wage or salary history to prospective employers. There is also protection from wage and salary history requirements. Employers cannot require that an applicant's prior wage or salary history meet certain criteria, or require that an applicant made a minimum amount previously in order to be considered for a new position. For more information on Equal Pay and Opportunities Act questions, contact the LNI APOA specialists, Devin Wesh and Jackie Ferrer-Thomas. Starting January 1st, 2023, all employers with 15 or more employees engaging in any business, industry, profession, or activity in Washington must disclose wage and salary information on job postings that recruit Washington-based employees. The job postings must include the wage scale or salary range, a general description of benefits, a general description of other compensation to be offered to the hired applicant. It is most important. This only applies to postings that meet the definition of a posting. So what is a posting exactly? A posting means any solicitation intended to recruit job applicants for a specific available position, including recruitment done directly by an employer or indirectly through a third party, and includes any postings done electronically or with a printed hard copy. That includes qualifications for desired applicants. If these requirements are not met, the employer has not made a defined posting and is not subject to the pay transparency requirements. Now that we know what a posting is, we can go over what is required in those postings as of January 1st, 2023. Employers will be required to include a wage scale or salary range that is the employer's most reasonable and genuinely expected range of compensation for the job. Here are some examples of what that would look like in hourly wages, yearly wages, and salary based on commission. Also included in the requirements is a general description of benefits and other compensation. Things that a general description of all benefits includes, but are not limited to, healthcare benefits, retirement benefits, any benefits permitting days off, including more generous paid sick leave accruals, parental leave, and paid time off or vacation benefits. Other compensation includes, but is not limited to, any bonuses, stock options, tuition reimbursements, sign-on bonuses, or other forms of compensation that would be offered to the hired applicant in order for their established salary range or wage scale. LNI has worked on implementing Administrative Policy ESE-1 to address the job posting requirements as a result of Engrossed Substitute Senate Bill 5761. The policy also provides guidance on the department's existing interpretations of the Act. We are also updating publications and other educational materials. You are welcome to attend webinars scheduled to inform the public about recent changes. We also offer individual presentations to inform your organizations about these changes, and you can also access a free employer consultation by contacting the APOA agents, Devin Wesh and Jackie Ferrer-Thomas. There are specific rules and laws that employers must follow to employ someone under the age of 18. Before hiring minors in your workplace, you must get a minor work permit endorsement on your business license from the Department of Revenue. You must get a completed parent school or summer authorization form and verify the minor's age. Keep a copy of one of the following on file: the birth certificate, driver's license, baptismal record, or a notarized statement from the parent or legal guardian. You must follow the legal age to work, job duties restrictions, hours of work limitations, applicable meal and rest break requirements, and appropriate wage requirements. The legal age to work in Washington is governed by state and federal child labor laws and varies based on the type of work, whether the job is considered hazardous or has prohibited duties, whether school is in session, the legal status of the minor, and whether the job is exempt from the Fair Labor Standards Act. For more information on youth employment questions, see the link at the bottom of this slide or contact the LNI Youth Employment Specialist, Reed Simic. Washington is an at-will state. This means employers do not need to establish cause or give notice before firing an employee. However, workers are protected from termination or retaliation for exercising a protected right or filing a complaint under certain employment laws. The Employment Standards Program covers the Minimum Wage Act protections, protected leave, Equal Pay and Opportunities Act, and other L&I protections, which include workers' comp and safety and health discrimination. You see these listed on the left-hand side of this slide. There are additional anti-discrimination programs offered by different agencies. We've included these agencies on the right-hand side of the slide as a resource for you. An employer cannot retaliate or take any adverse actions against employees for exercising a protected right, filing or intending to file a complaint, or discussing potential violations of their protected rights in regards to minimum wage, overtime, tips and gratuities, accrual and use of paid sick leave. The Employment Standards Retaliation Unit investigates prohibited adverse actions towards employees. Examples include when an employee has exercised a protected right and an employer terminates, suspends, demotes, or denies an employee of promotion, reduces the employee's hours or alters the employee's work schedules, reduces the employee's rate of pay, threatens to take or act upon the employee's immigration status or that of an employee's family member, or subjects the employee to discipline, including write-ups, verbal warnings, and points. For questions related to retaliation, contact the L&I Retaliation Unit Supervisor, Michael Davis. Employees have the right to file a wage complaint against their employer for unpaid final wages, agreed wages, overtime, minimum wage, tips and service charges, unpaid paid sick leave, NSF checks received as wage payment, or unauthorized deductions. House Bill 1794, passed during the 2022 legislative session, requires an employer to reimburse employee NSF fees when a paycheck is dishonored when submitted for payment. Employers are obligated to pay wages in full and reimburse the employee the full NSF fee if the paycheck was presented timely within 30 days to the employee's bank. An employer would not be liable for the fee reimbursement if they provide evidence from their financial institution that the payroll check was returned to NSF in error. The department also investigates non-wage complaints against employers for the following reasons: meal and rest periods not provided, child labor violations, retaliation due to a protected activity, protected leave violations, Equal Pay and Opportunities Act violations, and farm labor contractors not properly licensed. Other specialty areas within the Employment Standards Division include the isolated worker protections. Tiffany Lowry is the specialist, and agricultural labor, which includes farm labor contractors. Christina Rodriguez, the specialist. And I'm going to take you to our website, lni.wa.gov, and it's the three letters lni.wa.gov. This is the landing page. You come up to take on open workers' rights, and on this you'll see wages, ag policies, leave, workplace complaints, youth employment, workplace policies. Under each of these tabs is more information. Under the wages tab, you'll find information on the minimum wage, on Equal Pay and Opportunities Act, overtime and exemptions, getting paid, tips and service charges. The agricultural policies deals with your agricultural overtime, Workplace complaints deals with the complaints in the various areas of employment standards jurisdiction and how to file wage complaints online. Youth employment, and also workplace policies. Under this workplace policies, you'll see information on termination, retaliation, rest and meal break periods, personnel records, also isolated worker protections, and the new Transportation Network Company Drivers' Rights Program. I want to draw your attention to administrative policies. Under this section, you'll find documents that Employment Standards has created to show you how the various rules and regulations that have been handed down from the legislature are enforced by employment standards. Many of your questions, you may be able to find an answer going to these documents. They include documentation on minimum wage, on overtime, how to calculate overtime, the overtime exemptions for white-collar workers, also information on paid sick leave, industrial welfare, and then information on record keeping. So, and then of course, ESE 1 on the Equal Pay and Opportunities Act, which includes the information on the pay transparency requirements. I also want to draw your attention to the bottom of each of these web pages, and you'll see this link here, this Workshops and Training Center. This will take you to a calendar that shows you the various webinars that LNI offers on various topics and gives you an opportunity to select them, see what they're about, and even register to attend our various regularly scheduled webinars. Okay, back into the presentation. Other online resources that are available to you, I've included here links to some important administrative policies, ESA A1, which is the Minimum Wage Act applicability. Also the link to the administrative policy section so that you can find that. 8.1 on overtime, 8.2 on calculating overtime, ESC2 on hours worked, ESD1 on record keeping requirements, and of course ESE1 on EPOA. And these are also links to various information sections on our web page, minimum wage, jobs not paid overtime, various ones that may have answers to questions that may come up during your business operations, and give you a chance to try and find some answers to help you make your decisions how best to operate your business. And some more holiday vacation bereavement leave, ag policies, Equal Pay and Opportunities Act, youth employment, isolated worker, termination, retaliation, and again, that Workshops and Training Center, and our language services. And the educational webinars, again, this is the Workshops and Training section, and then our subscriber portal. This is where you can register to subscribe to the various emails coming out from various parts of employment standards when new rules or regulations or educational opportunities are presented. Employment Standards Outreach Team conducts educational webinars monthly. Each webinar addresses a particular area of employment standards responsibility and a particular audience. You may register for the webinars in the Workshops and Training Center, which is what I just showed you. Let's begin with the Employer's Guide to Workers' Rights and the Know Your Workers' Rights. This is an introduction to the Employment Standards Division from the perspective of employers and employees. Both presentations are available in Spanish upon request and are usually scheduled for the second and fourth Wednesdays of the month. And the presentation I've just made to you is kind of a truncated version of our Employer's Guide to Workers' Rights presentation. It's not the full presentation, but it's got a lot of the detail. EAP overtime exemptions is a detailed look at the rules and regulations for white-collar overtime exemptions for employees meeting the job duties and compensation requirements for executive, administrative, professional, computer professional, and outside sales exemptions. It's usually scheduled for the third Wednesday of the month. Equal Pay and Opportunities Act is an in-depth look at the regulations dealing with gender equality in the workplace and information on the new pay transparency and job postings rules. This webinar is presented by the EPOA specialists, Devin Wesh and Jackie Farrar-Thomas, and usually scheduled for the third Thursday of the month. Isolated worker protections is an in-depth look at the regulations dealing with isolated workers in the workplace. The webinar is presented by the isolated worker specialist, Tiffany Lowry, and usually scheduled for the second Thursday of the month. And finally, the understanding the changes in agricultural overtime laws. This is an in-depth look at the laws and regulations dealing with agricultural employment, especially considering the new laws making agricultural employees eligible for overtime. This webinar is presented by the Agricultural Employment Outreach Team and usually scheduled for the first Wednesday of the month in English and the fourth Thursday of the month in Spanish. LNI is focused on making sure that our services are accessible to everyone and that language is not an obstacle. Employment Standards provides these services at no cost: phone and in-person interpretation, document translation during audits, consultations, and investigations, and interpretation during webinars when requested in advance. Please contact the LNI Access Coordinator, Luz Gonzalez-Vergan, for more information and assistance. LNI's Civil Rights Program conducts internal investigations to ensure compliance with civil rights and discrimination laws. If you feel you have not received the services you need in your preferred language, or if you feel discriminated against, please fill out a complaint form online, call the program at the phone number listed, or visit your nearest LNI office. If you have any questions, feel free to contact us on our general line or email esgeneral@lni.wa.gov. The customer service specialist will assist you and direct you to a representative or a specialist promptly. Here also is the contact information for other specialists within the Employment Standards Division. We are continually updating our presentations to reflect changes in the laws and regulations under Employment Standards jurisdiction. We must advise you, however, that this content is as current as we have at the present time, but it is not presented to constitute legal, business, or regulatory advice. The information included herein is presented for general informational purposes only, and we make no express or implied guarantees based on the content of this presentation. And I want to thank you so much for the time this afternoon, and I hope the information has been helpful and will be useful to you as you pursue your business opportunities. And I would be more than happy to spend some time answering any questions that you may have. And as I said, I've already forwarded a PDF version of this PowerPoint to the people in charge of the presentation, and they can make those available to you if you require. So let me get out of this screen. And
Bob, thank you very much for that presentation. We do have a couple of questions
Yes.
that came through in the chat. The first is a question about PTO, paid time off versus paid sick leave.
Right.
They've been advised that the PTO can be used as sick leave, and as long as the benefit meets the same requirement. And she's just asking whether or not that is in fact correct. Or if there is-
Yeah, generally that is true. It depends. These are case by case situations. It depends on the employment contract. Usually, what happens is when an employee is exempt from the Minimum Wage Act, either through those white collar exemptions or other exemptions where they're not defined as an employee under the Minimum Wage Act, an employer would generally, instead of they're not eligible for, they don't have to be given paid sick leave, so they'll make PTO available. An employee that is not exempt, in other words, a minimum wage employee, or regardless of what salary they're making, if they're not exempt from the Minimum Wage Act, they are entitled to paid sick leave. So as a general rule, paid sick leave, paid time off can be synonymous, but if you've got a specific case that you're concerned about, we can take a look at it. Let me give you another address, and you'll also find it on the resource list that's on the PDF that you'll be getting, but I'll put it here in the chat box.
And while you're placing that in the chat, the second question had to do with where on the website the training calendar can be found.
Right. When you go to the website, lni.wa.gov, whatever page you're on, if you go to the bottom of that page down there, and there's a listing of all kinds of things down at the bottom, you're looking for workshops and training, and you just click on that and it'll take you right straight to that calendar.
Okay. And this would be the time if you could drop in the chat any other questions that you have for Bob.
Yes, and that estechnicaladvice@lni.wa.gov, that's the one that you would want to send that to. And any questions that we can't answer, we can get it to a specialist and make sure that you do get an answer. Go ahead. I didn't mean to interrupt you.
No, that's fine. That's fine. I'm not seeing any other questions coming in at this point. So
Okay.
I just first like to thank everyone for taking time out of your day to participate in the webinar. And a reminder that a recording and a copy of the slide deck will be coming to you tomorrow via email so that you can review it if you need. Bob, thank you again for making the presentation, and to the folks at LNI, And then we look forward to seeing everybody else at the next Mind What Matters. So thanks.
And thank you for having us here. We appreciate the opportunity.
You bet.